Good afternoon and welcome to our webinar, Reflecting During a Crisis, Are Your Legal Documents in Order? Nobody expected a pandemic, but we are in one. This is a good time to review your legal documents that everybody should have. And if you don't have the documents, this webinar today will help you think about what you need. I'm going to provide some suggestions as to how you can assess whether your legal documents are in order. This is Tammy Weber. I'm a certified elder law attorney and the managing attorney at Marshall, Parker & Weber. Thank you so much for joining us today. We're going to take questions at the end, if there are any. So as we go forward, jot them down or write them in the box, and then I'll answer them at the end. First, we're going to review some key legal documents. The type and amount of legal documents really is client specific. So some of these you may have and you may not need, or vice versa. First, a last will and testament, a financial power of attorney, a healthcare power of attorney, a trust, family limited partnership agreements, LLCs or other corporate entities, and beneficiary designations. These are the 6 categories of key legal documents that I will review for you today. Let's start with the last will and testament. So this is the document that you write and have witnesses sign and have notarized that covers things that you own that are in your name alone when you die. So for example, this could be your checking account, your savings account, a piece of real estate that's in your name alone, etc. Assets that aren't covered under your last will and testament would be things like jointly held real estate, if you own your property with your spouse as tenants by the entireties. If you were to die, your half of the property automatically is owned by your spouse. It doesn't come under your will. Another asset that might not be covered by your will is life insurance. Life insurance has a beneficiary designation. It's like a contract. So if you've listed your nephew as the beneficiary under your life insurance and you pass away, that life insurance goes directly to your nephew. Doesn't matter what your will says. An annuity or a retirement product would be something else that would go by a beneficiary designation. And often if you have a family business and there is an operating agreement and your share might pass through the provisions in that operating agreement. The second key legal document that you should have, everybody should have, is a financial power of attorney. This is a document that is during your lifetime. When you pass away, no power continues under your financial power of attorney. So in your financial power of attorney, you choose an agent. An agent is the one that's going to do things for you. You can have one agent or 2 agents or combine them. There are possibilities, and it depends upon what your circumstances are and what your desires are. The financial power of attorney will allow your agent to do things like sign checks with your checking account, forward your mail, get into your safe deposit box, sign your tax returns, and the like. The law changed as of January 1st, 2015 significantly with respect to financial powers of attorney. So there are also a category of powers that we call the hot powers, where when you write a financial power of attorney, you have to be very specific as to whether you want your agent to have that type of power. For example, gifting. Do you want your agent to be able to give your money or property to somebody else without receiving fair consideration? If you haven't done a financial power of attorney, or the agent or agents you've chosen are no longer available for some reason, either they've passed on, they're incompetent, they've moved, The only alternative in Pennsylvania is a guardianship proceeding, which is done in the court where you reside of the county. And although the laws have changed a bit in the past couple of years with respect to guardianship, it involves a physician doing a statement, testifying, or doing an affidavit that you are unable to appreciate the consequences and handle your estate. And your family members that all would inherit, should you die without a will, would have an opportunity to be your guardian and come in and talk or contest against other family members becoming your guardian. So the most of the time these go smoothly. Sometimes they don't. It's best to have your own choice. And the other consideration is cost. These can be multi-$1,000 events. So why not you plan ahead and have a financial power of attorney or update it as needed depending on your circumstances. The third key legal document is a healthcare power of attorney. Some attorneys divide this up and have things like a combined document that has finances and healthcare, and then have a living will or an advance directive or a post form specifically for end-of-life decision-making. It's really a choice here, but the way we like to approach a healthcare power of attorney at Marshall, Parker & Weber is to have one document that covers 3 categories. One is HIPAA, meaning the right to your private information. So your agent or agents would have the ability to do so. Second is what I call decision-making that's not going to affect whether you live or die. So say, for example, you are out in your local grocery store and you fall and you hit your head and you're unconscious, but there's been some breakage and some type of internal injuries nobody knows. The doctor says you're not going to pass away, but a decision has to be made about the timing and the type of treatment. That would be the second power under the healthcare power of attorney. And the third power would be end-of-life advance directive living will. So that's where you would put forth your philosophy as to whether or not you want treatment that will artificially prolong the process of dying. Should a doctor or doctors determine that you have an end-stage medical condition or you're permanently unconscious. So everybody has a different philosophy about this. Some of our clients would like at least 2 doctors to certify that they're at the end of their life. Just a good illustration that every legal document is not one size fits all. You really need to think about your personal circumstances and beliefs. So those are the 3 areas that a healthcare power of attorney document covers. If you don't have one, or your agents are all deceased or unavailable, Pennsylvania in January of 2007 passed Act 169. And that act may or may not reflect what your wishes would be, so it makes sense to have a document. What that act says is there's a list of default decision makers. So for example, if you are currently married to a spouse of 25 or 30 years, but you have adult children from a prior relationship, what the law says is those adult children and your current spouse all stand in place number 1 for decision making. So there's a possibility that your adult children, because majority rules, if you have more than one, could actually outvote your current spouse. That may not be what you want. There are also some restrictions on end of life. So for example, if what you think and have been communicating to your loved ones throughout your lifetime is if you're at the end of your life, you really don't want it prolonged, but you haven't done a healthcare power of attorney or similar document to lay those out, Act 169 says that you will get tube feeding and hydration. Next are trusts. There are 2 main kinds of trusts, revocable and irrevocable. And in those categories, we could talk for weeks about the different kinds of trusts. I'm just going to hit the high points. Revocable means that you can change your trust that you set up during your lifetime. In Pennsylvania, there are various reasons for revocable trusts. For many people, it is to have all their investments at one place and have one person managing them as they age. Maybe their sight is failing or something's going to happen. Most of the people that we work with, because we are an elder law planning firm, we recommend the irrevocable trust. An irrevocable trust means that once you set it up, you can't change it, only in some limited circumstances. So imagine, to illustrate what an irrevocable trust is, you go to your local bank, you walk in and you say to the banker or the teller, I'd like to open a safe deposit box. And you fill out the paperwork and they give you a key. And you take the key and you open the safe deposit box and you insert in that safe deposit box the things that you don't want to lose. You want them safe there. For many of our clients who have a goal of protecting their assets or having more options, if in the future they need to go to a nursing home or have nursing home level of care, this is the kind of trust they want. They want things, certain things, locked up in that safe deposit box, that irrevocable trust, so that after a 5-year look back, everything in it is protected from the cost of their care and they have some more options. And in a trust, there are provisions that say when you die, where the assets owned by the trust go. Another key legal document for some people and some families who have small family businesses in the area, it is a family partnership agreement. They may have incorporated, they might be an S Corp, they might be an LLC, but what we often see at our firm is some of the smaller businesses, when you say, well, what happens if you die, or what happens if you become incapacitated? Who's going to run the business? Who is going to get your share? And they have no document. They may say, well, my son's going to do it. Well, they may have never talked to their son. They may not have considered that their son may want to give his share to his spouse or his children. They don't anticipate what a succession plan is for their business, or at least they haven't put it to writing so that it's very clear that their intent is made known and legally binding. Many of the small businesses with which we work do not want the in-laws, meaning daughters-in-law, sons-in-law, or step-grandchildren, to be involved in the business at all, and some do. You also want to look at, if you have a key employee, what happens to them? Do you have key employee insurance? So those are some things to consider if this applies to you. And the sixth category of key legal documents we're just reviewing today are beneficiary designations. So they're like contracts. I referred to them earlier. So your life insurance, who you want it to go to. If you have an annuity contract or a retirement account, you want to, especially on retirement accounts, make sure that you've listed a beneficiary and a contingent beneficiary. Because if you have deferred the income tax, in other words, your retirement is in a traditional IRA or a 401k where you haven't paid the income tax, if you've listed your spouse as the beneficiary on your retirement account, your IRA, and you and your spouse both pass away at the same time and there's no contingent listed, then the IRS will want all the deferred income tax payable at that point in time, in addition to any inheritance tax that would be due. So it's very important, especially on retirement accounts, to have contingent beneficiaries listed. And finally, with retirement accounts, we've had a new passage in December of 2019, effective for deaths after January 1, 2020, the Secure Act and various considerations. So it's a detailed document, and essentially one of the big changes is if your retirement account is inherited by somebody other than your spouse, or a list of some other exceptions, they must take the money out within 10 years. There are many other changes, and on our website, paelderlaw.com, there are a series of 3 articles written in more detail about the Secure Act. So if you haven't heard about it, you should check into it, read those articles, and then look at your legal documents and see if it matches and you have the backups listed. So what we really want to focus on for the rest of our time today is, are your documents in order? So we thought of a few questions to help you think through, well, really, what does that mean? How would I know? Some people might say. So first look at it is your estate plan consistent? Does your will have your things that are in your name alone going to the same place as jointly owned assets or beneficiary-driven assets? Do you have many of your accounts? Some financial institutions will allow you to put a designation on your account called POD, which means payable on death, or TOD, which means transfer on death. Some people are confused, or they don't have all their professionals working together to make sure their estate plan consistent. Why could this be an issue? And if it is, if you do know and it is inconsistent and you want it to be, is it clear? Here's why. There have been many reported cases where somebody in their will says, I want my retirement accounts to go to my grandchildren. Yet the retirement accounts list their children as the beneficiaries. Under Pennsylvania law, the beneficiary listed really trumps what's in the will, but it does give cause for the grandchildren listed in the will to say, wait a minute, maybe my grandparent was confused, or that lawyer didn't do a good job, or the beneficiary designation form wasn't filled in correctly. You want your estate plan, to the extent it's possible, to be unassailable when you die. You don't want to leave a legacy of everybody fighting over your assets and where they're going. Sometimes there are reasons to have them inconsistent. So it might be, an example might be 5 children, they're leaving money only to the 4. The parents may have given money during lifetime to the 5th and didn't give anything to the other 4, so they've decided we're leaving him and her out. So sometimes it's important to write a note explaining that, putting it in the will. I know that under this will, I have not given anything to child number 5, and it was my specific intent to do so. And let your professional know. Do you have the same purpose or circumstances as when you did your estate plan as you do now? For example, since you've done your planning, is your spouse in a nursing home? If you died, would you want everything to go to him or her? You may, or you may not. Have you had a diagnosis of some kind of significant health issue? If so, that may impact where you want your money and your property to go. Have your beneficiaries changed? In other words, maybe this is the time, since you've done your estate planning, that you're now estranged from one of your beneficiaries, or one of them has passed on, or you've decided, boy, I really did a great job with my children. They are all grown. They are financially significant, ready to go. So I want to leave some of my money to my grandchildren instead. Or everybody's doing well. I've been working with this local charity and I want to leave that local charity some money. Look at your purpose and what you have. Another key determiner of whether your legal documents are in order is the dreaded inheritance tax for many people. So in Pennsylvania, if you die, inheritance tax starts on $1. As a review, for money or property going to spouse, the rate of tax is 0%. If it goes to your children, parents, grandchildren, the rate of tax is 4.5%. To siblings, it's 12%. And to nieces and nephews and everybody else, whether they're related to you or not, is 15%. It is 0% inheritance tax for money or property going to a qualified charity. And the big exception to all of this is if you own life insurance when you die, that rate of tax is 0% for whomever it goes to. But the question is there going to be money to pay the tax? This again is different for every circumstance. Say, for example, when you pass on, there's not a lot of money in your name alone. You have a house and a few $1,000s in your checking account, and you have some annuities and retirement accounts that are going to pass outside of your will. And you have different beneficiaries for all of them. If you currently have a paragraph in your will that says any inheritance tax that I owe when I die, I want to come out of the money in my account, there might not be enough. Or you might have an uneven, in terms of dollar amount, distribution to beneficiaries. So you could choose to say, I'd like the beneficiaries to pay in proportion to the amount of assets that they're inheriting from me. So look at how the items that you own are going to your beneficiaries. Because if you recall, if it's an annuity or retirement account, when you die, that's automatically their money, but inheritance tax still needs to be paid within 9 months of date of death. What if your fiduciary changes or needs to be made? So a fiduciary, as a review, is a person who is a person or an institution that's in charge of somebody else's money. It could be an executor, a power of attorney, an agent, a trustee, and the like. You might have personal trustees listed in your will or in your irrevocable trust. Are they still alive? Are they still doing well? Do you still get along? Do you think they're going to follow what you want? Look at those circumstances. On the professional fiduciary side, I often see clients who forget to double check, and their original intent when naming the local bank was because they wanted their beneficiaries to have somebody to go to see, to go if they have questions. And many of these local banks are merging with larger banks and perhaps moving out of the area and not having a local presence. Or they've changed their policies or their fees. All of these things are something that you can just check in on every once in a while. Beneficiary changes. So did somebody new die? Was somebody adopted? Do you have a guardian of a minor listed in your will? Or do you want to include somebody new? So for example, if you said, I'm leaving everything to my children, and if they predecease me, their share goes to their children. And at the time you did their will, all of their children were over the age of 18. But then there was a new grandchild that when you die is under the age of 18. If you haven't listed a guardian, then under Pennsylvania law, the default is the biological parent, which some people would not want. Are there stepchildren? Are they adopted? Did one of your beneficiaries die? If they did, do your documents make provision for that share? Has there been a health change? Or is somebody on public benefits? So earlier I said, what if your spouse goes into the nursing home? If you have what we refer to as I love you wills, and your spouse goes to the nursing home and you get him or her on Medicaid, medical assistance, which is the government program to pay for people with limited funds that need to be in a nursing home, and you forget to change your will and you die, and that says everything goes to my spouse in the nursing home, well, that money, most of it's going to go to the nursing home for their care. If that's what you want, that's fine. But there is a way to rewrite your will so that many of your assets could be used for your spouse in the nursing home for supplemental needs, but not have to go towards their care. And then we have the all interesting personal issues. This could be many things. Is one of your beneficiaries filing for bankruptcy? Maybe you don't want to leave money to them outright then. It could be in a special kind of trust in your will. Has one of your beneficiaries gotten a divorce? And did you not see it coming? And in your document, it said everything I leave to my son, and if he passes before me, to his wife. You probably need to change that. Did one of your beneficiaries get married to somebody new that you love, you don't like, you would never want them to see money, or boy, they are better with money than your child is? Think about it. Addiction is a big thing these days. Drugs, opiates, gambling. That's a personal issue that could impact the way in which you want your documents to be written and might need to be changed. Or has one of your beneficiaries been incarcerated? Again, there are ways to address that in your will by setting up testamentary trusts. And that means not during your lifetime, but they only come into play after you die under your last will and testament. And some other tips to review is keep all of your legal documents together. We give our clients a binder with some sleeves and a table of contents, and the documents that we write and help them sign are there with some extra places for things like contact information, for professional advisors. Where are the vendors? Where do you get your things for at the house, at the business? What are the account numbers and addresses? Are those monies or payments taken directly out of a specific checking or business checking account? What are your online usernames and passwords? Are they in a secure place? Where's the list of your assets? All of these things should be together in one place, and you can choose, and everybody's different, to tell your executor or your backup executor where these things are in the event of a crisis, or just give them our card if we're your attorney, and then they'll know who to call. And most specifically, you can visit our website for articles and other webinars that go into more detail about the various things that we've talked about today. I don't see that we have any questions today, so I am going to thank you for joining us, and take care, everyone.